Well, hello and welcome. I'm coming to you at my newish office. Welcome, everybody. Welcome. Hopefully, the sound is okay. Hopefully, you can hear me. We are just waiting for everything to go live. There's been a lot of talk. The talking heads are out about this case. What does this mean? Why is there no death penalty? Why are the families so angry? Apparently, it's only one family that's angry. I don't know. Maybe they. I don't get it. You've got to be able to move on at some point. I mean, it's a tragic event, yes, but dragging this through a trial just so you can get the death penalty, even if he gets the death penalty, it's going to take 20 years to get there, and then when he's dead, then what? You gonna feel better? I think it's time to move on. The most concerning thing for me is, well, I never really thought he was innocent. My biggest issue was that he did not, the information that was put out there didn't seem like it was enough. And I know the state was under a gag order and they didn't produce all the evidence. And I know there were some leaks that were out. But I don't know, man. To plead guilty, I feel like you got to know you did it, right? You can't, I don't know. I know some people confess, right? Confess under a stressful situation in a police interrogation that's going on and on for 36 hours after you've been in solitary confinement. Not at all talking about the Delphi case. That's different than being stone cold sober, walking into the courtroom and saying, I did these things, right? Which is presumably what we're going to get. Unless it is like what Law Kong says, it's April Fool's, a little bit late. But I have to imagine he's not going to do that unless he actually did do these things. And so I'm satisfied with it. There still might be some people out there that he's been railroaded. I can't get there if he's pleading guilty to these things. So that's what I'm at. The leaks are pretty damning. Yeah, the leaks are pretty damning. All the things by themselves, not so much. The fact that he bought a knife on Amazon, not so much. But when you combine that with the photographs, with the alleged fact that he had photographs on his phone of the victim's friends from throughout campus, if you include the fact that he was put on probationary status at the campus for being creepy amongst young ladies, if you take into account the Uber driver testimony, and that was one thing that was always a problem for me, because he got there supposedly at the same time as the Uber Eats driver, and I was like, how did this person not see him? If this person didn't see him, then we need more of a timeline, and the police don't have a longer timeline. So that's the problem for the state. And then apparently the Uber driver was interviewed like the next day, whatever. So they had that information. They were sitting on it. They weren't releasing it to the public. You take all of that, combined with the fact that he's pleading, I don't know. I feel like he probably did it. I don't know how you plead under duress to 4 counts of life sentences. If I truly didn't do it, I'd be like, man, I'm going to trial. I'm going to trial because I know I didn't do this. Right? You can understand. I deal with a lot of criminal defense. By the way, welcome. Hello. Welcome, everybody, to Making Law Simple. My name is David Helm, a licensed practicing attorney and recently now court-appointed criminal appellate attorney, which I'm excited about. New little adventure that I'm working on. I've got my first couple of cases going on that. So given that context, people take plea deals all the time to something maybe they didn't do either, but it's not because they didn't do nothing, right? Or they're not taking pleas to things they didn't do expecting life sentences. So that's the thing I get hung up on when we're talking about this particular plea deal. Sorry, I was working and I need to save a bunch of stuff here on my computer. And we're experimenting today. because I'm talking to you through my iPad, but I do have the screen up and running on my computer, so I can pull up the hearing once it goes live. I've been watching P. Diddy and his shenanigans, not guilty on all the major counts, which is kind of fun. Not that I care at all about P. Diddy, but I love it when the government gets smacked back a little bit. It kind of tickles me inside a little. I mean, I guess in theory, the death penalty could be enough for someone to choose to plead guilty. I couldn't. I don't know very many people that would be like, I didn't do it, but I'm okay with spending life in prison. Even with the death penalty. I couldn't do it. I couldn't be like, yeah, I had nothing to do with this, but I'm gonna take a plea. Now, if it was a plea down to, when I first heard there was a plea, I was thinking maybe it was down to something lesser, like second degree, and therefore he would have the possibility of parole. I'm like, okay, I could see that. You know, someone up against the death penalty with a possibility of parole, but not this offer. I just have to assume that he in fact did it. It's kind of creepy to think about. Maybe he got a cushy deal on a nice cell. I don't know. Maybe. I have a hard time with this. Thinking of a man with a lot to lose. Hey, Nick. Hey, if you want to join me, I know you got the backdoor access, sir. Come on in. We are just waiting for court to go live. We had the talking heads earlier on Law and Crime, and now they just went to this. So I'm not sure what's happening. It's supposed to be starting now, and I don't know what we got going on. But we're still live. I see the little scroller at the bottom, so we're not missing anything, which is good. Cold, hard reality. I think he is facing cold, hard reality. I think that is it. Hey, how are you?
Well, I'm good. I'm trying to survive the Swedish heat wave.
Yeah.
It hit
is it hot there?
It hit 90 degrees, and then it started to get cloudy, and I thought, yes, now I can open some windows and get some cool air in. No, it's completely still.
All you have to do, man, is hit the sauna and hit the sea. I heard he waived his appellate rights. Yeah, that's my understanding too. Now, generally speaking, I don't know Idaho law. If you plead guilty in Michigan, you waive the right to appeal the evidence, let's say, for lack of a better term. You waive the right to appeal the evidence against you, but you can still appeal your sentence. So I don't know what sort of plea deal this is, if he's waiving his right to even appeal the sentence, since they're life sentences. And that's what it sounds like. I don't know, Nick, Do you know anything else about that?
As far as I know, in Idaho, in murder one, there is only 2 sentences. It's either life without parole, or it is death penalty.
Firing squad.
If they have the aggravated circumstances. Then
now, Nick, I'm gonna give you a would you rather. Would you rather? You ever play Would You Rather? They have that in Sweden.
Sort of. So I mean, it usually is. If you don't want to answer, you have to drink.
Okay.
For some odd reason, every game in Sweden, sooner or later, you're drunk.
That's. I feel like that's designed on purpose.
Yeah.
It is very cold, and the days are short there, except for like a month in July.
Yeah.
Would you rather? You're convicted. The appeals are exhausted. Would you rather go out with the injection, which might fail? You might be like brain dead for a while, or firing squad, which I guess they could miss too. Idaho has a firing squad. I thought that was amazing.
Well, at least, I mean, pros and cons here. They might miss. And yeah.
I want to know, do I get blindfolded and a cigarette? Because if I'm going out, I'm smoking again.
I'm getting me one of those novelty cigars. Can I have a smoke? Yeah, good. I want this one. I mean, lethal injection, yeah, but they still put you to sleep before they inject the other stuff. So even if you are thrashing around because the whatever they put in your body, the Kool-Aid,
propofol or whatever it is.
Yeah, the Kool-Aid. You're still asleep and barely conscious.
Have you had surgery before with that stuff that knocks you out?
Yeah.
The anesthesia. You're instantly out.
Yeah.
There's no fighting it. You're just out. And you don't remember a thing. You don't know what's going on. And then it feels like a second has gone by and you're awake again. So I'm okay with that. I don't know if I'd want to do firing squad. I would be too nervous to stand up there. Like, strap me to a chair, make me feel comfortable, put a pillow behind my head. Let's see here. Will's got a question. But this highlights the truth of the criminal justice system. Trials like Karen Reed make us think everyone is innocent, but in reality, is that most of those facing murder actually did it. Yeah, that's true. That is true. We do have a high conviction rate in Michigan, in the United States. But in general, most of the people are guilty.
We had the luxury of these high... most murder cases that are streamed don't reach Law and Crime or Court TV because there's no controversy.
Yeah. There was a new trial that just began. I tweeted at you, by the way. A woman stabbied her husband.
Yeah.
It's kind of a boring case. It's not. There's not a ton of excitement to it, at least to the testimony.
Yeah.
But that's most cases.
Most cases. And I covered the Mosley trial last week. Also, the only thing interesting there was the defendant taking the stand and blaming the victim. And that didn't help in sentencing.
Yeah. Exactly.
And so most cases of murder, they probably got the right person. But we, through the medium we have here, with streaming and everything, we get to choose which cases we stream also. And for instance, the YSL trial started out as a mistake from me because I didn't think it was that long. But it was so much controversy around it. So much. And it became even worse with the prosecution. Now with the Mosley case, also Fulton County, the prosecutor was Mr. Abati, same prosecutor as in the YSL trial. And all of a sudden, I could see him act when he had evidence. Completely different person.
Yeah, and that's the one thing, everyone's talking about the Delphi trial because court, the cameras weren't allowed in. The confession seemed to be a lot of shakiness. People were questioning all the other things that were done in that case. And if that case was streamed or televised, from gavel to gavel,
it would have been bigger than the Karen Reed case.
Well, or would it have shut up a lot of people that otherwise are thinking, oh, there's some conspiracy and he was railroaded, right? It's possible because we don't know. We don't even have the transcripts.
Yeah,
right?
It's possible. We don't have that. We do have the transcripts.
Right, but we don't have.
But it's still months away because the court in Carroll County, Indiana, they simply refuse to release anything voluntarily, even when they get paid for the sticks. Supposedly, I want those pieces of evidence that fits into this stick. And there are still people waiting. And then when they get it, it's more often than not, it's not the evidence they were actually asking for.
Sorry, I wanted to put this up just so everyone can see what's going on. Oh, here we go.
Stephen Hitler, presiding judge.
Let me see that.
I was waiting to see if I had to boost the volume, but I think it'll be okay.
And now I started streaming to my channel as well.
Cool.
So I'm
All right,
piggyback.
this is CR0124316665. Defendant is present in custody with counsel Ms. Thompson, Ms. Jennings, and pardon me, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Miss Allen is here as well.
Miss
Your
Allen
Honor.
is here as well.
He forgot his name. He's just playing it off as
All
if
right,
he missed
we
someone.
are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case.
Really?
This
Who's
has
calling the
been
court? Come on,
extraordinarily
people.
disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement.
Oh, good.
I ask
Someone's
that you
getting in
not continue
trouble.
to mount such campaigns or to send me information like this, because again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as
I
well
used
as
to
what
like this.
penalties to ask for,
Dragging it
and
on.
what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it
that
before.
YouTuber is. Do you, Nick? I don't know.
Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July.
Woo, that's a lot to go through.
With the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others
Not
are
unlike a
escorted
wedding.
out of the courtroom before you start to leave.
We got to ask her later.
Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing.
I know everyone that's streaming this
Frankly,
on
some of them
YouTube
while
wants
they
him
were
to
on
not
some
leave.
vacation
Yeah.
prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication.
I mean, that's the only
All right.
interesting part that
That
might
said,
happen.
let's,
Other than that, it's a
Move
plea
to the
deal.
business of
Yeah.
today. I understand the state
It's going to be
and the
fairly basic.
defense
facts,
have
Yeah.
reached a plea agreement in this case. For the record,
And I
have
don't
a
think
written plea
Kohberger will
agreement
do
which
any
indicates
detailed
in
admissions.
the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another.
It's 4
Defendant,
life sentences
as
stacked
part
up
of the
on
plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35.
Can he apply for a pardon?
This is not a Rule 11 agreement. meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material
Brian
terms of the
is
plea agreement that the parties would like to make?
all the
Obviously,
way
the
on
plea
the
agreement,
top
the written plea
right
agreement will
screen
speak for itself. and be part
without
of
the
court
jacket,
record.
sitting with all the ladies.
State, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well.
Hey,
Will
Steve.
there be
right.
will there be a victim impact statement?
Miss,
That's
Yeah.
Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
so we will get some information. Okay, this can be gruesome.
Yes.
I think it's just going to be
And Mr.
basic.
Kohberg, just to
Yeah.
make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples.
Just the right
You would
thumbprint?
lose
That seems
any
odd.
right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right
And
to
they
hold public
analyzed the
office, and the right
thumbprint,
to
and
vote.
he
Do
wasn't
you
there.
understand the charges and all those possible consequences?
Yes.
Sorry, folks. Or they find it in other cases, and everybody's, oh shit.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that are that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As
I
you
doubt it, Judge.
as I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Is anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
Are they going to do sentencing
And
today?
counsel, obviously, there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
What,
Mr. Kohberger,
Johnny?
you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence?
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
That's what I'm wondering. Are they going to do sentencing a different day?
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory
I can't wait for his book to come out.
questionnaire that is purported to be filled out by you. Did you fill that
I do.
document out?
Idaho does have a son of
Did you
Sam law,
understand the
so
questions that you answered in this document?
Yes.
And are the answers that are outlined in this
Yeah,
document
but it'll keep
your
them
answers?
occupied. Nothing says you can't
Are those
publish it. You just
answers
can't make money off of it.
truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
They have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be
He's
compelled to
still basically
testify if
remaining
you
silent.
did not
He's
wish to
giving
had
up
you
any
not pled guilty.
information.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
Yeah.
All right, I want you to understand what the
If I
state
did
would have
not
had
do
to
it,
have
that'd be an
proven
awesome title.
at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right.
This is a typical plea agreement, guys, by the way. This is nothing
So as to
special.
count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As
Real
to
court
count
is
three,
boring.
the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Goncalves, a human being, by stabbing her, from which she died. As to count four,
Burglary
the
is
state would have had to have proven
essentially
that on or about
entering a
that same
home
date
with
in
the
Latah
intent to
County,
commit a felony.
Idaho, you did willfully,
We're entering a
unlawfully,
building
deliberately,
with the
with
intent to commit a
premeditation
felony.
and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
Haven't watched many burglary trials.
I want to also make for the record.
Can't think of one.
The defendant has
Well, Jody
provided
Harris.
with the guilty plea advisory
No, yeah.
form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
Yeah, he's always been very
And then
calm.
let
It's
me
kind of
ask
creepy.
you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Goncalves, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I'm watching
And
the
then on,
audience.
Or about
See if
November
they're
13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
What happened?
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho. for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business
Do you
on the
hear an
Moscow-Pullman
echo?
highway,
I do.
just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m.
It's in the stream, it's not us.
Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogen and Kaylee Goncalves. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogen's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Kernodle was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims.
Make sure you
I wanna
clear
make
that
clear
up.
so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 11.
That was my whole issue, was the
which is
timeline.
immediately next door
Yeah.
to the
Short.
west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murder.
I don't know. I think we all
Yeah.
searched
Evidence
K-bar
also will
knife and
suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate.
I mean, it seems like they got a lot of evidence against him.
Yeah,
Mr.
this is just a
Kohberger
summary.
proceeded
You're
to
right.
finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law
No,
enforcement at this
I-
point were aware of Mr.
Me and the
Kohberger,
prosecutor are not the same
accessing
person.
information
They're
about him, were
brothers.
trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return
Could you
to
imagine being
Idaho,
his parents?
a DNA sample was taken from him, and it matched
Horrible.
the DNA found on the knife sheath
Charge the parents.
at the crime
That's what I
scene.
say.
I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket
Yeah,
of cleaner
that
right
one
beside it.
I have questions about.
I think we can all.
He must have
look to
been
our own
covered
cars
in
and know
blood,
when
and
there's
you
compartments in the
can't
doors,
really
we
clean
try
a
to keep them
car that
clean when we
good.
put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And
Not unlike
state
that.
would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. Thank you.
Thank you.
Sounds like a lot of evidence.
Yeah.
What I want to know is how they got
Right,
onto him.
based on the state's
Yeah.
proffer, and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony,
Black hoodie.
how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Goncalves, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first-degree murder of Ethan Chapin, a human being. How do you plead, guilty or not guilty?
Guilty.
The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. Court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and
Well, I don't think he would if he wasn't guilty.
logistics that will be
Gina.
required
I
to
do
make
think
that
he
happen.
knew he did it. If he's
Without
pleading
trials
guilty.
going, it'll be a lot easier to
Yeah.
do that. So let's pick that week. Why don't we pick July 23rd
Yeah, I mean,
with the idea that if for some reason
the
we
difference
don't finish, we
between
could continue into the
the
24th.
death penalty and life in
We'll
prison
start at 9 in the morning.
is, I mean, it could take 20,
Does
30
that give
years
your team
before
enough
the
time, Sandra?
execution.
9 in the morning.
Yeah, but you're pleading to life
any
in
concerns
prison
with that
without
date?
the possibility of parole. I can't imagine you
No,
would
sir.
do that if you weren't
All right,
actually guilty.
Now,
Any
statistically,
reason why I should not
many
rescind
death
a
penalty
non-discrimination
cases
order?
still result in life in prison.
You're right. I
Yeah.
think that given the history of this case, it would be best if that remained in place through sentencing. So we have.
They're going to keep the
time
gag
to
order.
consider,
I can't get my interview with
the
Bryan
ability to
until then.
completely answer questions.
Dawn.
That would be the state's preference and recommendation.
Would have no objection for the order to remain.
So it's
in
not
place.
weird.
All right, I will, at this point,
I think
the idea to
what
keep it
put them
until,
over the edge was not being allowed a third-party culprit.
sentencing,
Yeah.
which
And,
time it would be
What
withdrawn.
there are a lot of evidence we haven't heard of.
in order to
For
give the
instance,
parties
just
the
recently we
space and
heard
time
about
to,
the
prepare
DoorDash
to,
person
what I'm sure will be
identified.
a deluge of,
We haven't seen that in
media
any
requests.
documents because
Um,
there was probably no way for the defense to actually argue against it.
Right, and the other thing too is if you're when you're facing criminal charges, you try to knock holes as much as you can in the state's case, even if it's not necessarily get a dismissal or an acquittal, but to get yourself as much leverage as possible when it comes to a plea deal. And until you've addressed all those potential evidentiary issues and all of that, you don't have all the possible cards you can play. Apparently, they had enough to get the death penalty off the table, right? So that's all they were able to do. But you wait until you've gone through everything. That's why it's appropriate to wait so long.
Mm.
That's at least my preliminary decision. at this
So it
point.
looks like July
We
23rd
can
is going to be
always revisit
sentenced.
if
I
it
don't know if I'm
seems,
going to stream
to
it.
be,
Nah.
I don't want to hear.
For some
a bunch of
reason,
families.
I should.
I might watch it a little bit, but I don't want to
That's
stream it.
Obviously, I don't think the defendant, a bond was ever set for the defendant.
The house was demolished because there
where
was
it would
nothing
be
left of
revoked,
evidentiary
the
value.
prior order
That
allowing him
house
to
was
become his
teared
voting
up.
clothes is revoked,
Almost every
and his
surface,
plea
every
no
rug,
longer
everything
presumption of innocence.
is in
And in
evidence.
fact, now the actual conviction
So-
for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
The defense's
The
job.
Trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get
I
word
don't
to
think
those that receive their summons that they won't be required to
his-
attend. So,
Even though she,
that said, again, if you
well,
would
she
all
can't
please wait
claim
for,
innocence
the
if she
parties
actually
and the
knows.
victims.
she has a
Well-
candor to the court.
No,
So-
she can't. If my client comes to me and says, I absolutely did this crime, I still have to represent him to the fullest
Yeah.
extent of the law. And I have to make sure the state does their job
Yeah,
and
yeah,
protects
definitely.
everyone's
But
due process rights.
but can you claim absolute innocence with the knowledge of the opposite?
Yeah. A defendant?
Okay.
Yeah, a defendant could say, hey, in there, could say, hey, I know I'm guilty, but I still want the state to have to prove it.
Yeah,
Something like
but, yes. In that regard, yes, you have to defend the client in any way, shape, or form. But
Mhm.
the statement from the defense is actual innocence. Some of them.
Yeah. Most of them say they're innocent.
Mm.
I didn't do nothing. I'm like, well, the evidence looks pretty rough.
No, I mean
Did.
not the defendant. The defense attorney in filings have stated innocence.
Well, they probably stated, and I am not looking at them. They probably stated something along the lines of Bryan invokes his or claims his innocence or whatever.
Yeah.
That sort of thing. But everyone is innocent as a matter of law until they either plead or are found guilty.
Yeah.
So, from a legal technical standpoint, the attorney is correct.
Families and
Now, what they
others
can't
that
do is
leave
condone
courtroom
perjury.
Before you do, I would appreciate it. And with that, we're adjourned.
So if your client is going to go on the stand and they're going to lie on the stand, then you can't put them on the stand because that would be condoning perjury. But short of that, you can absolutely do whatever. You have a job. It's not called lying. It's called representing your client. That was the first thing, Aaron. Yeah, maybe. Yeah, Salvador is innocent. He's always innocent.
Yeah, I mean, do I have a lot of questions regarding the phrase DNA? Definitely. But now we heard it's single source male DNA.
The interesting thing for me is out of all the thousands of people that could possibly have done this, how did they zero in on Bryan?
Yeah.
I'm not saying they did anything shady or it's not actually him. He's pleading guilty. So I'm going to assume that he is guilty. But how is it that they zeroed in on him? I'm fascinated by that. I want to know more about that.
Yeah. The initial, it might be this guy. Let's look into this guy because it's a student town. Everybody drives around. It was a party house. Yeah.
Will he have to? He already did. Will he have to stand in front of the court and admit that he killed them? He just did.
Yeah.
That's what we just saw. He said, yes, I am guilty of killing these 4 people and burglarizing the home. So that was it. Now, to the extent that he wants to say anything at sentencing, he has the right to. And I'm sure people are expecting him to and want him to offer some sort of explanation, but he doesn't have to. And so we'll have to wait and see. And that would be the only compelling reason why I might want to stream it or at least watch it, is because I want to know what he says. but I don't want to sit through 4 to 6 hours of families sobbing to get to that. So I just don't think I'm going to stream it.
Yeah, I mean, I made a conscious decision to not start checking in all of the documents. I mean, I've still heard a lot because we're all friends with Ella, so it's unavoidable. But
Right.
I wanted to go into the trial more or less as a juror. This is the first time I'm hearing all of this or most of it. And but yeah,
So
that won't happen.
yeah. So when we talk about a factual basis for the plea, there's a couple of ways to do it. The court can put it on the record based on like a police report or something if there's a no contest plea. Or the defense can do it, or the state can do it. And when you saw Nick's brother stand up there and talk for 20 minutes, that's what he was doing. He was putting the factual basis on the record. And then the court turned to Bryan and said, hey, you heard all of that. You want to plead guilty to that, knowing what the state would have presented in the factual basis for the plea. And he said yes, and then proceeded to plead guilty 5 times in a row. It's not what everybody wanted, but that is very typical. And that's a plea. That's a plea hearing.
Yeah. I mean, unless something absolutely earth-shattering is showing up in a few years' time, somebody is drunk and spilling the beans somewhere, and all of a sudden they found that guy's or those persons' DNA. I mean, the case is done.
Yeah. So that's all I got for you. I've got no streams coming up other than some Lego streams in the next week or so. I was planning on streaming this trial. I'm a little like, what is it called when you're like happy sad?
I mean, happy it's over, sad I don't get the facts. I mean, we got a summary, but I want to dig in, analyze what's actually being said on the stand. I want to look at, is that really, doesn't that white car on that look different from that white car over there? I wanted to dig in on those things.
I know, that's what we do, and this would have been a great trial for it. And I was looking forward to it. It was going to be my return to trial streaming with a vengeance, without Karen retrial taking away all my viewers. But oh well.
Yeah, and well, I am going to look into the Brian Marsh case. It's the same cops, investigators as in the Karen Reed case, and the difference is, he most likely did the deed. Problem is, they kind of forgot to have the search warrant before they went through his electronic devices. So everything they found, which is more or less the basis of everything they are alleging against him.
They didn't have a search warrant?
No, they had a written agreement between the DA and his attorney to go through the devices, but only for communications between him and Mrs. Walsh.
Oh.
But they went into the Google searches, they went in... they went in there, and then they wrote the warrant to search for the things they already saw, it seems.
Interesting. Well, so there's so many exceptions to that, and one of them I cannot stand is called the inevitability rule or whatever.
Yeah, they would have eventually they would have found out. Yeah,
eventually they would have found it, so it's okay. I hate that. That's not how this works. So if the judge doesn't accept the plea, that can be used against the defendant. So the defendant's statements may be used against him. And that's just, anything he says could be used against him. If for some reason the plea doesn't get entered at the end of the day, which is irrelevant here because it did, could be used against him. That's what the judge was warning him of when he was going through his rights. So never give it up under any circumstances. Can't look through it at all.
But this was when she was only missing, and so not helping at all would have been suspicious and would have probably turned them towards him sooner. But then again, they kind of did anyway. And I mean, it's so stupid because wife is missing, the husband is acting weird. You can get a search warrant on extremely vague things. You just need a right judge to sign off on it. So it's pure laziness. And now we have it in. We saw it in the Ken Reed case. We see it now in the Brian Walsh case. There are other cases boiling up. The Sandra Birchmore case. Oh, it's the same cops over and over again.
When are you starting that, or when's that trial start?
I'm not entirely sure because there was a hearing about a month ago. I'm going to stream that tomorrow or Friday.
Nice. Well, that's all we have. I need to get to the airport now. Thanks everyone for sticking around and watching this with us.
Yep.
And
Thank
check
you.
out Nick's channel. I'll put a link in the description below to Nick's channel. I didn't know he was joining me. And we'll see you guys later.
Yeah.
Take care.
Have a good one. Bye-bye.
When I was young, my